Okay, AB 260. Here's what this bill did. It reversed the Supreme Court decision of Woods versus City of Madison. In the Woods versus City of Madison case in 2003 held that the City of Madison, and then in effect of any other city or village, could within 3 miles of, for cities over 10,000 and villages villages and cities under 10,000, a mile and a half, deny plats based upon the proposed land use. Prior to that, and the case that controlled before is Gordy Boucher versus Madison, which is on the bottom of that analysis there. It held that they couldn't deny on land use, that they'd have to deny in what's called traditional land division authority. That's lot size street configurations. That case, in the Woods case, in effect gave cities and villages unlimited power to deny plats. And there, since then, we've had very few boundary agreements, very few attempts by cities and villages even to talk. They just say no. And a lot of times when they say no to developers, they turn around to the developer and say, but if you annex, we'll let you do it anyhow. In fact, that's the exact example that happened in Wood case. Now this bill, we had it in session 2 years ago, got it out of the Assembly on a significant vote, 69 to 30. Never could get it out of committee in the Senate. This time around, we got it out of the Assembly in February, got it over to the Senate. Actually had it in both houses, but the vote in the Senate was based on the Assembly vote. And it was scheduled a week ago from Thursday on April 15th. The League of Municipalities and Alliance clearly fought it. We had one other group, the Thousand Friends of Wisconsin, that also registered against it. But the League and the Alliance had made their push. They were hoping it would never get scheduled. Senator Kreitlow, who's from the Eau Claire area, was a strong advocate. He had tried 2 years ago and over the last year to see if there was some type of a middle ground, some kind of compromise. And he had pushed us as well to try to come up with it. But what actually happened in the end is I believe that the League and the Alliance got greedy and that they said, well, we'll agree to limit it to the 1.5 miles or half of what the law is on land use, or 3/4 of a mile, but we want a reversal of the Rice case, the Rice versus City of Oshkosh, in which the court held that the city couldn't put higher standards on development in the town than they had in their own city. That's a case from about 12, 15 years ago in which the developers in the town outside of Oshkosh had been told you have to have 5-rod roads, curb and gutter, sidewalks, and the city didn't even require that of their own developers in their own city, and the court said that was not right, they can't have higher standards. So we'd won that case 12 years ago, and now the League was asking to reverse that, plus get something out of the limits on the land use. When Kreitlow, as a senator and lead author, said that's not fair, I'm not for that, he just said no more negotiation. He went to the legislative majority leader, Senator Decker, and Senator Decker comes out of Wausau, and he sits in a tough spot because first of all he's got the city of Wausau and a lot of rural towns to the north, but he also has to lead his caucus, and he was concerned about some of the legislators. Julie Lassen was real concerned because of Stevens Point and Wisconsin Rapids, John Erpenbach in Dane County, part of Madison, Monroe, and some other cities. So he was real cautious. I will give Senator Decker all the credit for basically handling it in a way that on one day he said we're going to schedule it, and quite frankly the League and the Alliance didn't have amendments ready. They weren't prepared. And so the next day they were scrambling to get amendments. Julie Lassen did try to put an amendment together and get us to compromise. We just said we're not going to at this point. We've negotiated, nothing could be done, we're holding the ground. And we had some very significant votes. Initially there was an attempt to refer it to committee. That vote only got 11 out of the 33, so that signaled we were fairly strong. In fact, we had legislators from Milwaukee, Green Bay, who supported us, and I commend again Jolene and Ann because they did the legwork to get them at that point. The next attempt was to do an amendment that Julie had to basically cut that distance in half without the Rice case. So the League had said we'll try to get something. That failed. And the final concurrence, we had 27 legislators out of 33, including Senator Lassa, vote for concurrence. So that's a very positive bipartisan vote. Now here's where we're at, folks. It's not over. It's not done. Because the bill is available for the governor to sign. And the bill actually, because we're at the end of the session, can sit in the legislature for up to, I think, May 13th is the date, Jolene. And at that point, any bills that have passed will go to the governor. He then has 1 week to act on it. Now, we have not got a reading out of the governor's office.
I'd kind of like to say something.
Sir, go ahead, Jolene.
I'll come up right there.